Thank you, Chair Goodman and Vice Chair Simmons. My name is Chad Enright. I'm the Cashapp County Prosecutor. I'm here on behalf of WAPA. I was also on the SURSAC committee with Representative Griffey. We need a criminal law statute that focuses on treatment and not on punishment. This bill is a good step. It needs some work. A few issues. First of all, I really need to stress the importance of the crime lab testing and that being done in a timely manner. If that is not funded, if that is not done, this bill really goes nowhere. Second, the diversion programs. I have some concern that they're a bit prescriptive. There are going to be some situations where diversion is not appropriate. Somebody who has other charges pending. If you have a murder charge, I don't believe a diversion is appropriate. If you have a serious assault charge, a diversion is probably not appropriate. And so I think that is something that should be considered. Additionally, when we look at the diversion programs, I think that there are some issues that maybe need some clarification. The language suggests that the defendant would make the motion and the court would grant it. Typically, a diversion program requires prosecutor approval, and that has always been part of the process, and that is part of the executive function of the prosecutor. Treatment is important, but some of the treatment provisions need clarification. First of all, these programs need to be funded, and that is probably the most important part about the treatment programs. They need to, when you look at the provisions about transportation, I think there are going to be issues with the judicial conduct code, and can judges get involved in that? There is a section that limits this to courts of limited jurisdiction. We're going to have cases where there is a felony and a gross misdemeanor. We need to be able to charge both cases in the same court. I don't think that needs to be in there. I know that several people spoke in support of the mandatory 21 days. I don't believe that is always necessary. In fact, I think in most cases it's probably not necessary. I'm asking that you give us the discretion to impose a penalty, if a penalty is required, that is focused on that individual person. I want to end with this. You've heard from several mayors. Cities and counties are going to do something if you don't. They are preparing ordinances. In my county, a city has already prepared an ordinance. They're waiting to see if you will act. We will have different laws across this state, across our counties, if you don't act. Those laws are focused on punishment. You can do something that's focused on treatment. Thank you.
Thank you. I'm going to indulge the vice chair because it's her own prosecutor, but go ahead and ask a question.
Do you know how long I've waited to do this? Cashapp County Prosecutor's Office. How many times have you got me, huh? No. I'm just playing. Chad, thank you so much for coming and for your service on the SURSAC committee and for being my prosecutor, a wonderful, wonderful prosecutor. Anyway, I have a question. You said you don't want to have the diversion be a motion by the defendant because the prosecutor should, agree to that. How do you feel about the prosecutor then doing the motion to vacate a conviction after treatment? I
can tell you exactly how I think vacations are going to happen. I'm going to have a form in the courtroom. And as soon as the judge says you're done, we're going to reach over, we're going to grab that form, we're going to put the defendant's name on it, we're going to hand it forward, and the judge is going to sign it, and the case is going to be vacated.
Okay. So I can change it to make sure it's prosecutor-driven and not they have to go find a lawyer to help them vacate their conviction?
You would absolutely make those motions.
Thank you.
Terrific. Thank you very much.
Thank you.
Good to meet you.